So let us begin. I have been asked to speak to you about the topic of international contracts in relation to international commercial arbitration. Page 2. To accompany my verbal presentation, I have prepared a PowerPoint. And perhaps you have this in front of the screen before you, or maybe it has been printed off for you to follow along. In any case, at this point, we should all be on page 2, which gives you the outline of my presentation. You will see that there are 4 parts to it. Next page, please. So many things begin with a contract, an agreement entered into between 2 parties or more, freely, willingly, what we know as freedom of contract. The parties enter into such an agreement of their own free will. Should they not then also be able to choose the law that's going to govern the contract? In other words, should they not also have what we know as party autonomy? Should they not be entitled to decide the rules that will govern their agreement? It seems to follow that they should. But there is a balance to be struck. We know that there is no such thing as absolute freedom. Parties are not free to make any kind of agreement they wish. Clearly, a contract to commit an illegality is not enforceable. Similarly, a contract that includes illegalities may not be enforceable, either in its entirety or in part. These are contracts that go against the public order. A contract must fit within the legal order within which it is created, whether that's domestic or international. On the one hand, we recognize that contracts have to be made within an existing body of law, or the law of contract. On the other hand, we recognize that parties should be at liberty to make their own bargain. This is what we consider to be beneficial for trade and commerce. So at one extreme, we have absolute freedom, and at the other extreme, there is none. As we know, law is very much about creating a balance. There's a balance to be struck between the public interest and party autonomy, or freedom of contract. Within a given jurisdiction and within the law of contract in that jurisdiction, parties are essentially at liberty to make their own bargain. Next page, please. We may not even be aware of these possibly competing interests until we are faced with an international contract. Then perhaps for the first time we have to consider this balancing of interest. It usually arises when we are faced with a decision over which laws from which state should govern the contract, and we enter into the realm known as conflict of laws. Perhaps in addition to everything else about their contract, the parties have also stated which law should govern the contract. They may have selected the law of the state of either party, or perhaps even the law of a third party. On the screen, you should see a sample choice of law clause. As many of you know, especially those who have practiced in the area of international commercial law, it is quite common to see that the law of the state of New York is chosen, for example, because it is a body of law that many international lawyers are familiar with, whether they are practicing in the state of New York or in Bogotá or anywhere else. And similarly, not just lawyers, but also business persons are often familiar with the law in the state of New York. Is that a valid and enforceable clause? Can parties simply choose which law should govern their contract? Can I choose any law, even if it's favorable to me or to some other party? Next page, please. Well, nothing in law is ever simple. So in the first scenario, let's assume that the 2 states involved do not accept the concept of party autonomy. Nevertheless, we still have the issue of deciding which law should govern. Should it be the law of the contract in the state of party A, or the law of contract in the state of party B? Each state presumably has a set of rules for making that determination. In the second scenario, assume that both states involved do accept the concept of party autonomy. Once again, we still have the decision of which law should govern and whether the decision that was made by the parties should be determinative. The most complex scenario could be the last one, where one state accepts party autonomy and the other one does not. Next page, please. As we see, there are a complex set of variable outcomes in these situations. Clearly an effort to bring uniformity to these cases which simplify things and create more certainty for the parties. As we know, the one thing that business does not like is uncertainty. Business wants a clear set of rules to enable planning. It's the desire to establish greater certainty that was one of the inspirations for the Inter-American Convention on the law applicable to international contracts, or, as we know it, the Mexico Convention, which was adopted in 1994, signed by 5 countries and ratified by Mexico and Venezuela. Wait a minute, only 2 countries have ratified it? You say. Well, there are many possible reasons why that might be, but I would like to consider briefly with you the shift in legal culture that perhaps the Mexico Convention represents. Next page, please. Perhaps one of the most significant achievements of the Mexico Convention was to enshrine the principle of party autonomy. Of course, this does not mean that parties have absolute freedom. Party autonomy is outlined in Article 7, which you see on the screen, and it stipulates that the contract shall be governed by the law chosen by the parties. Nonetheless, there are certain limitations which you see as well on the screen. Under Article 5, this does not include determination of the law applicable to the capacity of the parties, or the consequences of nullity or invalidity as a result of lack of capacity. It doesn't apply to questions of company law, including capacity, function, and dissolution. Under Article 12, to establish that one of the parties has not duly consented, it's the judge that shall determine the applicable law. Article 13 contains provisions on the determination of validity as to form. So therefore, it's necessary to note at the outset that the Mexico Convention does not stand for complete and unrestrained party autonomy. That having been said, it must be noted that the Mexico Convention was quite a step in a new direction, given that traditionally countries in Latin America have not recognized this principle. So let's take a look briefly at the history to why that might be. Next page, please. Party autonomy was one of the fundamental principles of the Napoleonic Code and many of the codes that were developed from it. But this was not so in Latin America, where the principle of territoriality was paramount. This principle is essentially that every nation possesses an exclusive sovereignty and jurisdiction within its own territory. And the consequence is that the laws of every state will affect and bind directly all property within that territory, all persons within that territory, and all contracts made and acts done within it. Next page, please. The principle is simple and provides a single point of attachment at any given time. A person or piece of property is either inside or outside the territory and therefore only subject to the sovereignty of one state at any one time. This principle is well embedded in private international law. When embarking upon a conflict of laws analysis, an initial starting point is to consider a few basic maxims, one of which is the principle of territoriality. In addition, we find that the key instruments in private international law implicitly outlawed party autonomy. For example, the 1889 Montevideo Treaties on Private International Law, and then we see that this was explicitly reiterated in the 1940 Montevideo Treaty on International Civil Law. This treaty established that an international contract's center of gravity is the place of its performance. Pursuant to Article 37 of that treaty, the law of the place of performance is what governs all fundamental aspects of the contract, such as existence, nature, validity, effect, consequence, and performance. When it becomes impossible to determine the place where the contract is to be performed, then we turn to the subsidiary connection factor set forth by Article 40, the place of conclusion of the contract. So why was this principle of territoriality so important in Latin America? Why were concerns over sovereignty historically so paramount? One can only speculate, but I leave that discussion for another day. Next page, please. In the second half of the last century, we see evidence of movement away from adherence to the maxim of territoriality and the principles of international law that followed. Consider the unidroit principles, for example, the first set in 1994, which were revised in 2004 and most recently in 2014. As provided in the preamble, these principles apply when the parties have so agreed. Thereby, party autonomy is implicitly recognized. And interestingly, UNIDROIT membership includes 13 OAS member states. So the Mexico Convention and the preparatory work that led up to its conclusion and adoption in 1994 was part of a process. Although it has not been ratified and signed by many, the fact is that it was being worked on with the participation of a large representative body from the OAS membership. The 5th Specialized Conference on Private International Law, or CEDAW 5, was attended by 17 Latin American states, plus Canada and the US, and this represents consensus of a considerable number of nations, including both civil and common law countries. And so it was another brick in the sidewalk of the path towards party autonomy. And most recently, we have had recognition of the Hague Principles on choice of law in international commercial contracts. All of this recognizes that there's had been a gradual recognition and a strengthening of the principle of party autonomy. Next page, please. In the face of this, we also see individual actions by countries within the Americas that indicate a gradual shift towards acceptance of this principle. For example, Mexico and Venezuela, clearly, these are the 2 states that have ratified the Mexico Convention. Paraguay in 2015 became the first state to formally consider and implement the Hague Principles by incorporating them into their domestic law. We also have Mercosur documents, the Buenos Aires Protocol on International Jurisdiction in Contractual Matters, which states, quote, "In conflicts related to international civil or commercial contracts, the competent court shall be that of the state party that the contracting parties have agreed to in writing, provided consent was not obtained under duress," unquote. Guatemala, Article 1519 of the Civil Code, authorizes party autonomy provided the law selected does not conflict with mandatory laws or with public policy. Now, I'm not quite sure if that's current, but that is an article that we have on record here rather recently. Similar provisions are included in the Code of El Salvador, Chile. Rules of private international law in Brazil and Argentina have also contemplated similar provisions. Next page, please. But Jeannette, we're here to discuss arbitration. So let us now turn to part 2 and consider how the previous discussion on international contracts is relevant to international commercial arbitration. You may wish to take a break at this point and discuss with your colleagues what this discussion that we've had on international contract may mean for the second part. Thank you. So as we noted at the beginning, many things begin with a contract. Arbitration does not happen without the consent of the parties. The parties must agree to arbitration, either in an arbitration clause within an agreement, which might be considered as a mini-contract, or by means of a separate arbitration agreement. As has been acknowledged widely, party autonomy is a foundational principle of arbitration, a key principle of current arbitration law, and the cornerstone of modern arbitration. Next page, please. But once again, balance is required, balance of competing interests. On the one hand, parties want a prompt, inexpensive, and final resolution to their dispute. On the other hand, states want to ensure that the arbitral process is just and impartial. So we have this paradox that arbitration must be free from courts in order to be effective, but it also needs the support of national courts in order to be effective. That balance, of course, has been the subject of many judicial deliberations, intellectual debates, and published articles. The parties to an arbitration agreement make a conscious decision to exclude court jurisdiction in preference for the finality and expediency of the arbitral process. Therefore, protecting the arbitral process from unpredictable and disruptive court interference is essential. Similarly, it is argued that if parties include a choice of law clause, that it too should be upheld. If an arbitrator were to apply any other law other than what the parties have chosen, this would be contrary to the parties' wishes, would undermine party autonomy, and furthermore would undermine the faith of the international business community in the institution of arbitration. So we see this balance played out in the arbitration conventions themselves. Next page, please. I've started here with the text of the New York Convention, but as we will see, the language of the Panama Convention is quite similar. You see that on the screen above that you have before you. Article 1 recognizes the principle of party autonomy. Each contracting state shall recognize an agreement in writing under which the parties undertake to submit to arbitration. Next page, please. Article 2 recognizes the need for the support of the court under the limited circumstances of paragraph 3, which you see there on the screen before you. Interesting that the similar concepts to those which we heard earlier in the discussion of the Mexico Convention, the similar grounds for judicial review we see here. Next page, please. These have the circumstances of Article 5. Recognition and enforcement of the award may be refused only if that party furnishes to the competent authority where the recognition and enforcement is sought proof that the parties to the agreement were under some incapacity, were not given proper notice, the award deals with matters beyond the scope of the agreement, or the composition of the arbitral authority or procedures not in accordance with the agreement, or that the award has not yet become binding. Next page, please. Paragraph 2, recognition and enforcement of an arbitral award may also be refused if it's found that the subject matter of the difference is not capable of settlement by arbitration under the law of that country, or that recognition of the award would be contrary to the public policy of that country. Next page, please. Here we have the language from the Panama Convention that recognizes party autonomy. An agreement in which the parties undertake to submit to arbitral decision is valid. Next page, please. Here we have Article 5 of the Panama Convention, recognition of the need for court supervision. In other words, the public interest aspect. The language of Article 5 here is virtually identical to that in the New York Convention, which we have just reviewed. Next page, please. In the summary table that you see on the screen, which is current as of about April of 2015, of the 34 OAS member states, 28 have ratified the New York Convention and 19 have ratified the Panama Convention. What I presented to you so far in part 1 is the argument that there has been implicit acceptance that party autonomy has been emerging as a fundamental principle in the law of contract in Latin America, irrespective of the lack of ratification of the Mexico Convention. We have seen evidence in other areas, including the evolution of developments in the international arena, such as the UNIDROIT principles and the recent Hague principles. Secondly, I would like to argue that ratification of the arbitral conventions, New York and Panama, demonstrates by states party that there has been an explicit acceptance of party autonomy. Given the recognition of party autonomy in these conventions, I would suggest to you that indeed This is evidence of the recognition of the principle of party autonomy by the states party to these conventions. It's another piece of evidence, if you will, to support the argument I presented in part one of this presentation, that even absent widespread ratification of the Mexico Convention, party autonomy is alive and well in Latin America. Would you agree? Next page, please. Having made that argument, like a good lawyer should, I'm going to argue it against myself. I'd like to explore some scenarios that are not an argument necessarily against party autonomy, but do invite a little closer examination, more like a cautionary note. One of the reasons perhaps for the reluctance of Latin American states to fully embrace party autonomy in the past has been over concerns in situations where there is an inequality of bargaining power. Of course, within the realm of international commercial arbitration, we would like to think that the parties enter into a contract freely that represents a good bargain for both sides. But what about other kinds of contracts where perhaps there isn't the equality of bargaining power? What about consumer contracts? What about franchise agreements? What about small-scale farming operations? Next page, please. How many of you have ever entered into a contract for a rental vehicle with all those tiny clauses that you can barely read? Or consider when you sign up to make a purchase online and you're required to agree to the terms. In some cases, you cannot even simply click I agree without having to scroll all the way down to the end. This presumably gives you some appearance that you have a choice. Do you as a consumer really have a choice? Does anyone ever read those clauses? I know that they're long and boring. I mean, they've been written by lawyers, so of course they're going to be long and boring. But is that really the reason? No, it's essentially because you either have the choice of accepting the terms or you don't buy the book. That's the only option you really have. These are what are usually referred to as adhesion contracts, a standard form where one of the parties sets the terms and has all the bargaining power. Next page, please. In 2003, OAS member states by General Assembly resolution convened the 7th CD and selected as the topics for consideration, 1, consumer protection, and 2, secured transactions registries. We're not going to be talking about the second one today. 2 working groups of experts were established and subsequently met to discuss these topics. It was noted at the beginning that the topic of consumer protection was being addressed as a complement to CEDAW 5, the Mexico Convention deliberations, which did not address this matter. The need for consumer protection was recognized. But it is one thing to want to work on a topic. In the area of international harmonization and codification, one of the necessities and frequently a precursor to the selection of a topic is the determination of whether there is a sufficient degree of ripeness and a possibility of achieving consensus. Ultimately, on this topic, the positions were simply too divergent. Next page, please. The balance between the powers of the state to regulate the rules of contract vis-a-vis party autonomy has come to the forefront once again, particularly in relation to arbitration and in relation to consumer protection. The challenge frequently faced by the consumer is that individual action is often not practical because the amount of individual recovery against an unscrupulous seller would be insufficient to justify bringing a separate action. Although numerous consumers are exposed to the same unscrupulous seller, as no single individual can afford to take action, the seller retains the benefit of wrongful conduct. Consequently, this state of affairs has led to the class action suit. But in recent years, sellers have been inserting arbitration clauses into consumer contracts, whereby the consumer agrees to arbitration and to waive any kind of class action, whether by litigation or arbitration. And again, this is usually a clause in small print in a standard contract. You'll see a sample clause in the screen in front of you. Next page, please. Let's look at a decision from California in 2005. that has come to be referred to as the Discover Bank rule. The plaintiff consumer alleged that Discover Bank represented to credit card holders that late payment fees would not be assessed if payment was received by a certain date. But in actuality, fees were being assessed if payment was received after 1 o'clock in the afternoon. This led to damages that were small for each individual consumer, but large in the aggregate. So the plaintiff in this suit filed a complaint claiming damages for this alleged deceptive practice, and the bank successfully moved to compel arbitration pursuant to its arbitration agreement. The plaintiff sought to pursue class-wide arbitration, and the bank relied on the contractual waiver clause. In its ruling, the California Supreme Court held that class waivers in consumer arbitration agreements are unconscionable if the agreement is in an adhesion contract, disputes between the parties are likely to involve small amounts of damages, and the party with inferior bargaining power alleges a deliberate scheme to defraud. And this is what became known as the Discover Bank rule. Next page, please. That decision has since been overruled by 2 recent decisions of the US Supreme Court that have, quote, enshrined the use of class action bans in arbitration clauses, unquote. Let's look at the first of these 2 cases. In AT&T Mobility, the plaintiffs, Concepciones, had entered into a contract with AT&T for cell phone service, which was advertised as including a free phone. They were not charged for the phone, but they were charged sales tax on the retail value of the so-called free phone in the amount of about $30. Therefore, they commenced a lawsuit that was consolidated into a class action with other consumers, alleging that AT&T had engaged in false advertising and fraud by charging sales tax on free phones. The contract provided for arbitration of all disputes between the parties, but required that claims be brought in the party's individual capacity and not as a plaintiff or class member in any purported class or representative proceeding. AT&T brought a motion to compel arbitration under the contract. The California Federal Court denied the motion, relying on the Discover Bank rule, which we just looked at. It found that the arbitration provision was unconscionable because it disallowed class-wide proceedings. The case then went to the US Supreme Court, which framed the question in the case as being as follows: whether Section 2 of the Federal Arbitration Act, which you see in the screen before you, preempts, or otherwise overrules, the Discover Bank rule. And the US Supreme Court found that it does. It ultimately upheld the fundamental principle that arbitration is a matter of contract. That language that you see in the FAA requires that an agreement to arbitrate be enforced unless a party successfully challenges the formation of the arbitration agreement, such as by proving fraud or duress, something that essentially relates to the defects in the making of the agreement. Next page, please. A similar decision was rendered in American Express versus Italian Colors Restaurant. A group of merchants who accept American Express credit cards brought an action against American Express for violation of federal antitrust laws, alleging that American Express uses its monopoly power in the market for charge cards to force merchants to accept rates that are 30% higher than the fees for competing credit cards. American Express brought a motion to compel individual arbitration. The US Supreme Court found nothing in the FAA that would allow the court to invalidate a contractual waiver of class arbitration. The FAA does not permit courts to invalidate a contractual waiver of class arbitration just because the cost of proceeding on an individual basis outweighs any potential recovery. the FAA reflects the overarching principle that arbitration is a matter of contract and courts must rigorously enforce arbitration agreements according to their terms. Next page, please. So although the circumstances of the cases that led to these decisions are such that the outcomes may seem insignificant, the consumers lost the right to recover a minor sum under a credit card agreement or a cell phone contract. The consequences of these decisions are quite significant. They extend far beyond to a much wider range of cases, as was described in an investigative piece of journalism by the New York Times that you see in the quote on the screen. Such class action waiver clauses are increasingly being included in employment contracts, especially in the low-wage sectors such as the food and beverage industry and retail industry. As a result, unfair labor practices and discrimination may continue hidden from other workers who may be experiencing the same thing. As a result of inserting individual arbitration clauses into consumer contracts, companies have devised a way to circumvent the courts and bar people from joining together in class action suits, which realistically are often the only tool that citizens have to fight illegal or deceitful business practices. This has been described by one judge as, quote, being among the most profound shifts in U.S. legal history, unquote. And the two U.S. Supreme Court decisions have been described as having, quote, upended decades of jurisprudence put in place to protect consumers and employees, unquote. Next page, please. But why am I talking about U.S. case law? What relevance does it have to you and students of international commercial arbitration? Well, for three reasons. First of all, remember the choice of law clause that we talked about earlier. The law of New York, this is the law in the state of New York, for example. In the American Express case, we would just have to change the facts a little and it would become relevant. The case was brought by a group of merchants. Consider, for example, if that group of merchants was in Mexico, a state which clearly accepts the concept of party autonomy. And consider that perhaps there was a choice of law clause where the law that governs the contract would be the law of the state of New York. Then all of a sudden, these issues become quite relevant to students of international commercial arbitration. Secondly, the relevance is there for things related to online dispute resolution. I know that that's another kettle of fish. There are a number of very complex issues that have yet to be resolved, but it's worth bearing in mind. Thirdly, we can also consider the implication of jurisprudence. Frequently, what happens with U.S. companies in the U.S. is something that is initiated there and frequently follows in other areas globally. So these are things to be concerned about when we look at the progress in terms of arbitration and the direction that things are going in the future. Next page, please. Another area where there may be potential for the use of these types of clauses may be in contract farming. This is a type of activity that has been around for a long time, but its formalization is perhaps rather recent. It's essentially the production of agricultural commodities under contract between producers and buyers. It is not so huge right now, but is expected to grow tremendously over the next 30 years as food commodity firms seek to ensure their access to supply of production. Next page, please. The context for the production of the legal guide to contract farming are circumstances where there frequently exists imbalance of power. The contractual provisions can be highly complex, and usually the relationship is one that the parties expect will continue for many years. Under these circumstances, it was considered that such a guide would be very useful and was produced by the FAO in conjunction with other partners. Its key contributions have been listed on the screen for you. 1, reduction of informality. Secondly, preserving freedom of contract. 3, advancing equitable default rules. 4, identifying the issues that require mandatory rules, and 5, facilitating extrajudicial resolution of disputes. So I wanted merely to bring this to your attention as another area for consideration in the years ahead. Next page, please. What I hope to do in this presentation today was to review with you the principles of party autonomy in the context of international contracts and the relationship between that principle and its relevance for international commercial arbitration. I hope that what I have demonstrated is the constant need for vigilance, especially in the public interest, for the consideration of the weaker party or those with unequal bargaining power. Law is always changing because our society is always changing. The law is a vibrant, living instrument, and it is a tool for change. There will always be the need for the balance of competing interests. Today, I have tried to illustrate that balance, the balance between party autonomy and the public interest. This balance is very much like standing on top of a teeter-totter. It's when you stop paying attention, that's when there's the risk of losing the balance. Next page, please. I'm very sorry that I could not participate in the International School in person. I hope that you are enjoying your event and that you're learning a lot. Even though the OAS Secretariat could not come to you this time, you can always come to us. Please consider applying for an internship. We welcome students 3 times a year, winter, summer, and fall. I invite you to visit the website and consider submitting an application. Muchas gracias por su atención. Estoy encantada de responder a cualquier pregunta que ustedes pueden tener para mí. Muchas gracias.